All right, the meeting room will come to order. The secretary will take a silent roll. We have a quorum and are ready for work. First item of business committee is the approval of the minutes of February 9th. Has anyone had the opportunity to review those minutes? Representative Cannon.
I've read the minutes from February 9th and would move for their approval.
Thank you. The motion is to approve the minutes. Is there discussion on the motion? Seeing none, all those in favor, aye. Opposed, nay. Motion passes and the minutes are approved. As a second matter, preliminary matter, there's a lot of stuff on the OneDrive today for your review, including Attorney General Wasden's presentation. But first, I'd like to bring your attention to a letter addressed to Co-Chair Harkin, or Vice Chair Harkin, with regard to another subcommittee. I had said that if we had a second one, I'd use the half of the committee that wasn't on the first one. And you can see there, Representative Harkin will chair a landlord-tenant subcommittee for consideration of House Bills 45 and 152 with Representatives Kirby, Amador, Ehart, Scott, Erickson, McCrosty, and Nash. So we will make time for them accordingly. Since we're third item of business, and then I'll quickly move on. Our time frame on the agenda is until 4 o'clock, but naturally, since we have to adjourn in time to be on the floor by House rule, it will actually be much more compressed than that. So, without further ado, we'd like to welcome to the committee for the first time, Attorney General Lawrence Wasden. And Attorney General, I don't think the mic has been turned on.
Figure out how to do that.
All right, thank you.
Thank you. I'm not a technologist, so Mr. Chairman, thank you for the opportunity. This is the first time I've been asked to personally be present before your committee, and I'm grateful for the opportunity. And so I appreciate it very much. I would also make note that my Chief Deputy Sherm Fury is joining us by Zoom, as is my Budget Director, Robin Lockett. I also have present with me Brian Kane, who many of you know, and Chris McCormick from the Internet Crimes Against Children Unit. And we at the appropriate point would stand for questions. But I've been asked by you, Mr. Chairman, to talk a little bit about our budget, and so I will do that. And to introduce that, I really felt like it was important for us to talk about what it is that I actually do, because there's a lot of misunderstanding. Both in the press, in the public, and even among legislators about what the Office of the Attorney General was for. And by statute, I have the responsibility of representing state officials. And I am, in a certain sense, a captive lawyer. And that is that with regard to most state agencies, they are required to get their legal resources from me, and I'm required to give them those legal resources. However, there's another category of persons, and that is the governor, the legislature, and the judiciary. I am a captive lawyer, but they are not a captive client. They have the authority to select their counsel outside my office without asking me. And they're free to do that, and they do that regularly. Now, you may ask, do the courts get sued? And the answer is yes, and they regularly ask us to represent them. Sometimes they do, sometimes they don't. When I'm asked by those three entities, the legislature, the judiciary, or the governor, to represent them, I'm required to do so, and I readily do so. It's not a problem, and if they don't ask me, that's not a problem either. There are a number of small boards and commissions that they may ask me to provide them legal resources, and I can provide them legal resources. However, that depends upon the budgeting cycle. Sometimes they don't want me to provide them resources, and I don't, and then they get themselves into a legal jam, and they come running to me, and they want me to represent them. The problem is the appropriation power lies in the hands of the legislature, and they give me, number one, they give me FTPs, and number two, they give me dollars. And if it doesn't fit within that confines, it's very difficult for me to be able to provide them those legal services. So recognizing that that's the function, it's important to know the difference between policy and the law. And not everyone understands that. This body is the policymaking function of government. You get to choose policy A and policy B. If you choose policy A, then you are, by definition, rejecting policy B. And when you do that and you create a law, my job comes into effect with regard to that law. It's not the policy that I am defending, it's the law that you have written that I am defending. And so my job is to do two things. Number one is to give you legal advice. Now, it's important to recognize that I only do so upon your request. In the very same sense, I only represent the legislature upon their request. The law also says that I'm required to provide you a legal opinion upon your request. So I don't just go out and write legal opinions just for entertainment's sake. I do so when I'm asked by a member of the legislature or certain other officers that are named in the statute, and I am to answer questions regarding the law, and that is, what does the Constitution say? How does this interact with other statutes? Those are the kinds of questions that I entertain. It isn't, is this a good law or is this a bad law? That's a policy choice that you make. That's not a policy choice that I make. And a lot of folks get confused. One person said to me, well, you always tell me my bills are unconstitutional. You don't like me. And that's not really relevant to the issue. The issue is, does it fit within the confines of the Constitution or doesn't it? And so I say yes or no. And quite frankly, it doesn't matter whether I agree or disagree with what the statute says or what the Constitution says. I took an oath to uphold the Constitution. I took an oath to uphold the laws. And so it's what does that say that matters. It's not what I personally think. And so sometimes folks get confused believing that when I render an opinion, it's my personal view. And it's not my personal view. It may be, it may not be. But what I think personally is not relevant. In the very same sense that when I give you a piece of advice, it's not basically what you like or dislike either. It's what does the law say, and that is how I can, as the Attorney General, provide you the greatest service, is to tell you what those legal pitfalls are. You can then either maneuver around them or through them or however you choose to, but the best thing for me to do is to give you that kind of advice. There's three things that I think really need to be pointed out. One of them is something we call the rule of law. And the rule of law is that everybody is subject to the law. Doesn't matter who we are. Doesn't matter whether we agree or disagree. We're all subject to that law. Another thing that's very important to recognize is the principle of federalism. And people don't always understand what the principle of federalism means. Federalism is not only we separate sovereignty responsibilities among a federal government, a national government, but among state governments. And each of those state governments is independent from all the others. It's that entire concept, which is federalism. The other issue that I think is important is separation of powers. I think this is a term that you understand, but that it is one branch of government cannot exercise the power and authority of another branch of government. To do so violates the Constitution. It is a principle that has served us well for over 200 years in this nation. And what that means is that I need to be careful in making sure that I don't cross the line and attempt to do what you do here in the legislature. And by the very same token, it's important that you don't cross the line and try to undertake what I have a responsibility to do, because that's what's required by the Constitution. A few of you I have, and when any matter is before us, before me, there's two factors that really play a role. And that is, number one, what are the facts? Not the perceived facts, but what are the actual facts? And secondly, what is the law? And it's really a process of taking those facts and applying the law to those facts and coming with an outcome. Again, it doesn't matter whether I like it or dislike it. It doesn't matter whether I agree or disagree. What matters is, what are the facts? What is the law? That equals the outcome. I've used this analogy in a couple of instances, so if you've already heard it, I apologize, but I think it does illustrate the point. Let's suppose that you and I are driving down the road in a car. I look up, I see a red light. You turn to me, and you say, what color is the light? I have two answers I can give you. I can tell you the truth, and I can say the light is red. Or I can lie to you and I can tell you that the light is green. Here's the problem if I'm willing to lie to you and tell you the light is green. We'll make a decision that is ill-advised, and we're going to go into an intersection, and we're going to risk getting hit. The best thing I can do for you is tell you the truth that the light is red. You can then make appropriate kinds of decisions that you weigh the risks, and you then can make a proper decision. So I'd like to turn for a moment then to my budget, which is what you asked me to talk about. And in fiscal year 2020, my office recovered just under $33 million. The legislature's appropriation for my office function was $26.4 million. That means for every dollar spent on my office budget, we returned $1.25 to Idaho citizens. And throughout the year, my office continued to add value to state government by offering expert legal counsel to state agencies and officers and to the legislature. My office's work over the last year reflected the two important functions of my office. First, to provide legal advice to clients before they make a decision, and second, to advocate on behalf of those clients after they make a decision. I recognize that my counsel is not always what some want to hear, but my guarantee has always been that the opinions, decisions, and defense of our laws will be straightforward and firmly grounded in the rule of law. Because my job is to call balls and strikes fairly and squarely, and that's exactly what I have tried very much to do. And I'm as committed to that principle now as I ever have been. Pursuant to statute, the Idaho Attorney General does not submit a performance evaluation to the Division of Financial Management. However, I would like to share with you some of the accomplishments of my office over the past year. Please let me take a moment to acknowledge the work of my deputies and staff as they have undertaken to advise our state officers in the COVID-19 response. In addition to the typical legal work that we perform every year, my office has been the primary legal advisor to state officers as they've dealt with this pandemic. I'm proud of the work my team has done under these unprecedented circumstances and the additional hours and effort it has required. All of the achievements I'm about to mention happened in spite of the difficult conditions caused by COVID-19, and they happened because of an incredibly talented and dedicated group of attorneys and staff. In 2020, the Consumer Protection Division obtained over $1.4 million in consumer restitution and received over $1.1 million in civil penalties, fees, and costs. This combined amount of over $2.5 million equals $2.62 for each taxpayer dollar appropriated for consumer operations in fiscal 2021. At the close of fiscal year 2020, more than $321,000 in unspent funds from the consumer protection account were transferred to the general fund. This is done pursuant to statute when at the end of the year, those monies are swept by the legislature into the general fund. This brought the total amount transferred to the general fund since 2000 to more than $45 million. In 2020, Idaho received more than $20 million from tobacco companies, stemming from the 1998 Tobacco Master Settlement Agreement, and we expect a similar payment this year. That will bring Idaho's total Master Settlement Agreement payments to over $500 million, all of which has been deposited into Idaho's Millennium Fund. But securing these payments requires significant legal work and a substantial amount of expenses as tobacco companies vigorously fight to reduce their payments. In fiscal year 2020, my office incurred just under $200,000 in tobacco litigation expenses, and that included the cost of general litigation and expert witnesses. The Consumer Protection Division also concluded 14 pending matters, including a $1.5 million settlement involving the three largest gasoline retailers in Idaho. After an extensive investigation, my office concluded that these businesses sold gasoline at an excessive or exorbitant price during an emergency, as prohibited by statute that you passed. My Consumer Protection Division continues to participate in two ongoing antitrust price-fixing cases involving over 20 generic drug manufacturers and over 130 generic drugs. We also filed antitrust cases against Google and Facebook. We are also actively litigating against America's largest opioid manufacturers and distributors, including Purdue Pharma, members of the Sackler family, and Johnson & Johnson to help Idaho and its citizens recover from the ongoing opioid crisis. In highlights from other divisions, attorneys assigned to the Department of Health and Welfare set a new record, recouping over $9 million in Medicaid estate recovery. This year, civil litigation attorneys successfully defended Idaho's initiative process before the United States Supreme Court. They worked closely with the Idaho Department of Correction to obtain a federal district court order and decision terminating a class action brought by inmates against the department 39 years ago. They also assisted the Department of Labor in clearing the backlog of unemployment claims that were created by the pandemic. Attorneys in the Natural Resources Division continued to protect Idaho's sovereignty against encroachment by the federal government under the Endangered Species Act. They prevailed in 2 recent cases, which will help ensure that Idaho is allowed to manage elk and grizzly bears. They continue to support the legislature and the governor in cases involving salmon and sage grouse to protect Idahoans from onerous federal mandates. The Fair Hearings Unit continues to conduct all administrative appeal hearings for the Department of Health and Welfare, and this work expands over 6 divisions and 40 programs. During fiscal year 2020, the Fair Hearings Unit received 628 new cases, conducted 376 hearings, and closed 625 cases. The unit provides the state with annual cost savings in excess of $250,000 annually over the prior use of private attorneys as hearing officers. Finally, I want to mention lump sum spending authority. This tool is critical for managing our budget, which consists of 88% personnel and just 12% for operations. When extenuating circumstances arise mid-year, rather than having to ask for a supplemental appropriation, lump sum authority provides immediate resources where they are needed most, and this ensures that my office is able to maintain appropriate level of service for our clients. Mr. Chairman and members of the committee, that wraps up my initial comments. I would like to turn to Chris McCormick, who is the commander of our Internet Crimes Against Children Task Force, and allow him to tell you what ICAC is up to. And then we will stand for questions, Mr. Chairman.
Thank you, Mr. Attorney General. Mr. McCormick, welcome.
Afternoon, everyone. My name is Chris McCormick. I do oversee the Internet Crimes Against Children Task Force here in the state of Idaho, and I think most of us are familiar with ICAC or have heard that. Thank you. Have heard this or seen this on TV, but I just want to briefly go in what it is we do as well as what we've been able to accomplish throughout the state this past year. You know, our case origins, we're a little bit unique. We don't get 911 that comes into our office. The vast majority of the cases our office work comes from NCMEC referrals. NCMEC stands for the National Center for Missing and Exploited Children. So what that is essentially a nationwide clearinghouse for all these types of offenses that revolve around children and technology. You know, we're a coalition of state, federal, and local resources that investigate and prosecute these types of crimes. So this goes into this national clearinghouse, then that is disseminated to each of the ICACs throughout the country. So for Idaho, we are the repository for all NCMEC referrals for the state of Idaho. That accounts for anywhere between 20 and 80 new cases per week. There's quite a bit that comes through our facility. We're also self-generating our cases just like anyone else. You know, we will go off of based off of tips from the community, off of proactive operations, as well as peer-to-peer operations. We also, it's not uncommon for us to identify additional victims going into investigation. You know, as an example, we may be investigating an enticement involving Sally, and we go through and we serve a search warrant on a device. We go through the suspect's devices, we talk to him, we interview him. And through that, it's not uncommon to determine that, well, not only is he offending on, you know, this little girl, but also Becky and Monique and several others. So it branches off more often than I think a lot of people appreciate. And then lastly, you know, we are a very niche area of law enforcement. And because of that, we're often asked to assist with both investigation and forensic assistance with agencies throughout the state. We will always assist others. We don't have the resources to inherit or to adopt these cases on our own, but we will always assist other agencies with this. And this can be everything as little as providing guidance on what we would recommend they would do, up to and including working from start to finish in tandem with that investigator to make sure that it's done properly. And we are a great resource, and because of that, a lot of people rely on us for our expertise. Metrics we've got, well, at least in front of me, I want to kind of clarify this to make the distinction. The Idaho ICAC task force is actually two parts. We've got the Idaho ICAC unit, which is 18 of us that work these types of cases full-time, day in, day out, throughout the weekends, throughout the nights. It's made up of 9 full-time Office Attorney General staff, such as myself, and it's complemented by another 9 full-time investigators are loaned to us from other agencies. So we have 18 of us that are dealing with cases throughout the state. So as a collective unit, we've opened nearly 1,500 cases this year. The vast majority have been cyber tips. We've conducted 36 search warrants, which have resulted in 47 arrests. A couple numbers to pay attention here. Presentations. You know, nipping something in the bud before it happens is very important to us. We try to get out there and visit the schools, try to visit the civic groups, the churches. Obviously, COVID shut that down for obvious reasons, and that's dropped off to about 27. But we've supplemented that or offset that by trying to put these resources available on our website. The last number is probably the most crucial. Pending cyber tips in the queue. We've got 18 of us. We travel from Bonners Ferry to Twin Falls to you name it. I mean, we're always constantly moving. As of 2 days ago, we have 797 cases in the queue. What that means is they have been triaged. We've determined there's a need. We just don't have the manpower to assign them to an investigator. Sorry, technical difficulties. Okay. Kind of small, but what this does is it represents the activity throughout the state. What we've got is around the Ada metro area, we're about 1,000 cases we worked in 2020. Up north, we've got another couple hundred we work in Kootenai County. Worked another 70 or 80 on the eastern side of the state in Bannock, Bonneville area. You notice the badges. We've got 9 full-time affiliates. We've got one in Kootenai County, up in Coeur d'Alene. We've got Moscow PD. We've got Ada County. We've got Garden City Police, Caldwell Police, Boise Police, and Meridian Police. So these are complementing the 9 investigators we currently have that are assisting our office. And again, these are the ones working these day in and day out. Made the distinction between unit versus task force. The unit, as I said, conducts this as their prime function. That's complemented by the task force, which is essentially a couple investigators in this agency, some up north, some east. And what these are investigators that are a little bit more knowledgeable in these types of crime, but they don't work this day in and day out. So we're able to call on them. They work these types of cases in their respective jurisdictions. So if we get something up in Clearwater County, or we get something up in Bonners Ferry, we're able to call on these individuals and say, hey, we need some help with this. Or conversely, they're going to reach out to us and say, hey, you know, I've got this case, I need some assistance, and we'll send as many people as we can up there to help them. This slide right here is what makes it worthwhile. What our guys do and see day in and day out, these are images, these are sounds, these are things that nobody should have to see. But this is why we do it. You know, in Boise earlier this year, we served a search warrant on a suspected child porn case. Turns out that the individual was molesting or offending on children in the house. You know, a few months later, we did a multi-jurisdictional proactive operation in Caldwell. That resulted in 5 arrests of individuals traveling from as far away as Blackfoot to meet with what they thought to be a 12-year-old girl to have sex. And the last one was a priority 1 call out. And what that means is NACMEC, although we're not 911, we still are contacted 24/7. So these guys reached out to us. This is an in-progress call, rallied together. I believe the troops were out there for about 24 hours straight. And at the end of that, not only did they make the arrest, but they rescued 2 children that were being offended on in the house. So this is what brings us all together. And this is why I'm so proud of my troops. You know, where you hear about us, you see us, but I'm not sure you really know the effectiveness of what we do. It's very prevalent throughout there. The numbers I've given you is simply as a unit. Understand that a lot of these cases are being worked in the respective jurisdictions, and that isn't reflected here. So in closing, we do appreciate all the support we've received. You know, we've got a vast amount of support behind us. We also recognize that we couldn't have accomplished what we have without it. So I appreciate your time.
Thank you. Are there, Representative Hart?
Mr. Chairman, I won't belabor this because I know we have a long schedule, but I just have to say this. I was one of them who pushed for the extra ICAC help in Southeast Idaho and Idaho Falls, and it's disturbing to say that it's been put to good use. I cannot even imagine seeing the things you see on a daily basis, but thank goodness we have you, and thank you for what you and your team does. We appreciate it.
Thank you, ma'am.
Certainly. Representative Troy? Okay. See no further questions for you. Thank you so much for coming. All right. A question for the Attorney General.
Thank you, Mr. Chairman and Attorney General. Thank you so much for being here. We appreciate so much all you do. I was curious about your comments about your fair hearings officers because I have struggled with that in my district. And my constituents sometimes don't understand that when they come before an agency and one of your DAGs is in the room, that it becomes really a courtroom, and sometimes they've come and not been prepared. And I've gotten a lot of frustrated calls from some of my constituents who feel like they've been treated unfairly. So I just was wondering, is there a better way to do this? It feels like there is a bit of a conflict of interest when there's a DAG that's assigned to an agency that has relationships within that agency and really understands the goals of that agency. And sometimes it appears that they are not willing to hear the other side of the story in a fair way. And that, I'm very troubled by this. I cannot say that strongly enough.
Mr. Chairman.
Go ahead.
Representative Troy. The Fair Hearings Unit operates in a segregated way, and that is that they aren't part of that agency. They actually fall under our auspices, and then what they do is the agency has a right to be heard in front of that hearing, as well as the individual has a right to be heard in front of that hearing. And that's what they do. They're not part of the normal hierarchy that exists, and they're separate for that very reason, to provide a better way of having hearings. And as a consequence, they're neither for nor against either side. It's brought before them as a new matter. They do fall within the auspices of the Attorney General, but they are not agency dictated in that way. And that's the whole reason we do it, and that's the structure that the legislature has set up, and that's why we do it. Does that answer your question, Representative?
For a comment.
Go ahead.
Thank you, Mr. Chairman, for a comment. And I appreciate that's how it's set up, is to be that way. And on the surface, it does appear to make sense. But on the flip side of that, we are also assuming then that the agency has provided our citizens with a clear understanding of what's going to happen, that they have treated that citizen fairly, have provided that citizens the opportunity to tell their side of the story. And I am not finding that always to be the case. And so I continue to be troubled by that, Mr. Chairman. I know we've talked about this in the past, and I do think we need to find a path forward that works better for some of our citizens. Thank you, Mr. Chairman.
Thank you,
And
Representative
thank you,
Scott.
AG.
Thank you.
Representative Scott?
Thank you, Mr. Chairman. AG Watson, I was going to say Mr. Waston. This is maybe an
Chairman,
odd...
Representative Scott, could you speak up a little bit? I'm having a hard time hearing you.
Thank you, Mr. Chairman. Mr. Wasden, My question is, what led to the locking of the AG's office? I think that's happened since I've been here, and I get a lot of questions from constituents when they come here to visit the Capitol. What led to the lockdown of the AG's office?
I won't ask you to comment on that publicly, especially since I would imagine, without knowing, that there may be security protocols implied. If you want to speak generically you may, but I won't ask you to address that specifically.
Thank you. Mr. Chairman, Representative Scott, you and I can talk offline and I can explain to you, but I will tell you that there were security reasons that door was locked, and they were sufficient and they were significant security reasons.
Seeing no, Representative Scott.
Mr. Chairman, Mr. Attorney General, with your current budget, I was wondering how you're doing with retention of attorneys and recruitment of attorneys.
Go ahead.
Thank you, Mr. Cheney and Representative Skog. You and I have known each other a long time. It's nice to see you again, and congratulations on your election to this body. Our current budget, we are able to adequately satisfy our personnel needs. I will tell you that we are, in relationship to the private marketplace, we're way underpaid in terms of years of experience and responsibilities. We can go through that. I don't have those figures at my fingertips. Currently, we're able to retain our folks. There is always a bit of turnover, and I can give you more specifics probably on another occasion. So, thank you.
See no further questions. Thank you so much.
Thank you, Mr. Chairman. I appreciate very much the opportunity again. This is a rare occasion that I've been asked to, or given the opportunity to present to a committee, and I thank you very much for this opportunity.
Thank you very much.
Thanks.
All right, committee, before we go further, I'd like, do you have everything? You have the card and stuff? No. Oh, so we're not ready yet? Yeah. All right, well, never mind about what we'll do. Before we go on, we will just go on. Senate Bill 1027, Representative Ehart.
Mr. Chairman.
Welcome.
Thank you. Mr. Chairman, I'm Representative Barbara Ehart from District 33. Mr. Chairman, committee, thank you for allowing us to present this bill today. I do have some comments. I'd like to reserve those, but in all fairness, I think that this should be started by the good gentleman who had been a member of our body last year, Senator Doug Ricks. He started this process. He's seen it through. And I would like to turn the time over to him and reserve a few comments for myself after him, if that's permissible.
Certainly.
Okay.
Senator, do you yield?
Thank you.
I do. Welcome back. We've spent many hours together in this room.
Thank you. For the record, Mr. Chairman, I'm Doug Ricks, Senator from District 34. I am pleased to be back here, and I did enjoy spending many hours, most of the time. Sometimes it went very long on some of our meetings, but I do enjoy coming back here to be part of this committee today and be able to present to you. In fact, if you'll indulge me as a kind of an honorary thing, I am wearing my representative badge underneath here, just to show some respect and appreciation, because I really do appreciate this committee and this body. And I still consider you friends. But I'm pleased to be back. As you know, the bill we had last year for wrongful conviction sailed through both bodies very easily, and then it was vetoed by the governor. And so we're bringing back a similar bill. There's not a lot of changes that were made to it, but there were a few. And we are hopeful that this will go through and that we'll make sure that this gets passed. We have worked with the governor's office over the summer and made a few adjustments of things that they suggested, and I'll discuss those here in a few minutes. But most of you have heard the presentation, and there are a few new members here, and I will try to be brief on this, but I do want to kind of frame it right here. When someone's sent to prison, we take away their most fundamental rights. We take away their freedom. And all of us can agree that when this happens to somebody that's truly innocent, then that's a big problem. That's one of the worst things we can do. In cases where that does happen, we can try to examine and try to figure out, well, what happened? Whose fault was it? Was it law enforcement? Was it the attorneys? Was it the jury? Was it the judge? How do you pinpoint this? And I know with this particular bill, and it has been brought up and asked for me for, well, maybe we should go after the one that probably is the most guilty here that caused this. And it's hard to do that. It's hard to really pinpoint because there's so many people involved. And so we come up with the idea that this just needs to be fixed and we need to try to provide some compensation. And that's what this bill does, and it's based on general funds. But prisons are punitive. They're designed to punish people, and in most cases, rightfully so. But when that happens to somebody that is in fact truly innocent, that's quite a tragedy, and we owe that person a debt. Our society does. Currently, there's no process in Idaho to compensate somebody who's been incarcerated, put in jail wrongfully, and forced to serve many years. And this bill provides an opportunity to try to remedy that and fix that. Wrongful convictions rob a person of their time, the opportunity to have a meaningful part of build a family, have a career, college. A lot of those things are taken away from somebody, depending on how many years they spend. Idaho is one of only 15 states that does not provide a method of compensating somebody who's been wrongfully incarcerated for a crime that they did not commit. Even when an innocent person is exonerated and let out of jail, there really is no services available for that person. In most cases, they're let off out of the prison, and somebody's usually there, and their attorney or somebody to pick them up, but there's no services. Even folks who have been incarcerated and for crimes they did commit, normally when they come out, there's a period of around 6 months where they start receiving reentry services. They get help with resumes, they get help with housing, even a little bit of money to try to transition back into society. But currently, there's not really a process for that for those that are let out because they were exonerated. They're literally dropped off on the side of the street, which is, again, another travesty. Under this bill, it would fix that. So if it ever happens again, those transitional services would be there. This bill also provides $62,000 per year for every year a person was wrongfully forced to be in jail, incarcerated, or $75,000 for somebody who was on death row. Additionally, it would provide $25,000 per year for $25,000 for each year wrongfully spent on parole on the sex offender registry. So to be eligible for this, of course, the person would have to meet the test. There's some very narrowly crafted guidelines and requirements. They would have to meet that. They would also have to present this back in the district court and let a judge just verify that all the test has been made and completed. There is a provision in here, so if somebody who is in this position brings a lawsuit to a local jurisdiction, there's an offset. If there is a civil award and a settlement paid to the exoneree, that you get essentially the higher of the two, essentially not able to double dip on the same amounts. So exonerees would have 2 years from the date of this bill. It becomes law to apply for the compensation. We've identified that there's only potentially 6 people who have been released that would fit this, and more likely only 4 could qualify. This bill was drafted with the input from judges, prosecutors, defense attorneys, the advocacy community, and the Idaho court system. We've had a lot of input. So last year, the governor vetoed House Bill 384, and the main difference between the two, just briefly, is we had $60,000 in last year's bill per year, plus we had included some medical insurance for up to 8 years and some tuition waivers for college credits up to 120 credits. We've removed those on the request of the governor's office. They felt that that was an unfunded mandate, and we've upped the compensation by $2,000 more, so it's $62,000 a year for every year they were forced to be in jail. We've also changed it to a one lump sum payment. Last year's bill had it kind of timed out over a period of time, I think $89,000 a year. They didn't like the idea of doing an annuity type of a basis payment, so we're doing that in one lump payment. There is an emergency clause in this particular bill, so once it does become law and effective, it would go into effect, and anybody who fits this category could immediately file and go in the process to receive that compensation. But good committee members, this is a great bill. It's one I think all of us can get behind, and you know, we spend a lot of time talking about laws and trying to stop people that are doing harm to others, and that's a lot about what our laws and judiciary system is about. But we need to take responsibility when we get the wrong person and they are truly innocent, and take care of that, and that's what this bill does. So I do ask for your support in it. We've got some others who will testify, and I'll stand for any questions.
Representative Gannon?
Thank you, Mr. Chairman. I didn't realize there were other people to testify, but I would just make the motion to send this to the floor with a due pass. It's probably one of the best bills this legislature could pass.
All right, thank you. And thank you, Senator. I see no questions. We have...
Thank you.
Greg, and I'm sorry, Doctor, I think I struggled last year as well. Hampikian? He's here in person.
Thanks very much. I'm just here to answer any questions if anyone has them. Otherwise, I'll just turn my time over to Christopher Tapp. Are there any questions?
All right, thank you. And actually, I
Thank
recall
you, Mr.
receiving a notice that his online sign-up was to make way for Terry Shumway. So go ahead, and the one marked for him, let's bring Mr. Shumway up. Okay. All right. Mr. Tapp, welcome. Welcome back.
Thank you so much. Thank you, Chairman Cheney. My name is Christopher Tapp. Hold on. I want to thank Senator Ricks and Representative Ehart for sponsoring this legislation, and all the members of the committee for considering this important bill today. Some of you heard testimony from me on this bill last year, and I thank you for your support. I sincerely hope that this bill passes again this year and is signed into law. I'm grateful for the opportunity to be here again. When I heard this bill was vetoed, I was heartbroken. I thought of Charles Fain, another exonerated Iowan who's in his 70s and continues to work to support himself after losing 18 years on death row for a horrible crime he didn't commit. I hope he does not have to wait another year to try again. I ask you for your support for this bill. In 1998, I was found guilty of a rape and murder that I did not commit. I spent 20 years and 53 days in prison while the real perpetrator walked free. In 2017, I was released from prison, and 2 years later, in 2019, my innocence was finally confirmed by DNA evidence and the DNA donor admitting he acted alone in this horrible crime. I am so grateful for the tenacity of Carol Dodge, the mother of the woman who I was wrongfully convicted of raping and murdering, and the relentless efforts of the Idaho Innocence Project, Judges for Justice, my public offender, John Thomas, the Innocence Project, and countless others that helped me. Thanks to those like Carol and the Idaho Innocence Project who never gave up, I'm able to be here in front of you today and not sitting in a prison cell for a horrible crime that someone else committed. I cannot put into words the feeling of finally confirming my innocence after more than 2 decades in prison. Being in prison is as horrible as you can imagine, and being there when you're innocent is that much worse. I missed out on 20 years of my life. I wasn't able to spend my father's last years with him or go to his funeral when he passed. I was released from prison with nothing but my freedom. I had no financial resources, no way to rebuild my life and to meet my daily needs. I was released with no more than the clothes on my back, left completely reliant on friends and family to help me while I tried to rebuild my life. Finding employment was challenging because even though DNA confirmed that I was innocent and the courts recognized this and vacated my conviction, I still had a felony conviction on my record that prevented me from getting most jobs. I lost 20 years of earnings for my future and was left labeled as a felony. A felony conviction making it hard to start making up for lost time. I am humbled to stand here before you today and be able to speak on behalf of all the wrongfully convicted innocent people. I am so grateful that you're considering this bill that would provide a way for exonerees to restart their lives once freed. I strongly support this bill so when an innocent person exonerated in Idaho, they have financial help to start rebuilding their lives. I thank you for your time and urge you to pass this bill. Thank you.
Thank you. Thank you very much for your advocacy and your presence here. I see no lights, so
Thanks, Chairman.
thank you very much. I have John and Jolyn Thomas. No? Okay. Representative Ehart.
Thank you, Mr. Chairman. Committee, again, I'm representing Barbara Ehart, District 33, and I'll be brief. First, let me say that it's an honor to work with Senator Doug Ricks. This is a much-needed piece of legislation. You know, in March of 2017, I was on the Idaho Falls City Council, and I walked down to the courthouse as the proceedings were taking place with Mr. Tapp. And I sat there with many of his friends, family members, people who had gathered to see exactly if he would actually be set free that day, though many things had already been worked out. I believe I was the only elected official there, sitting, waiting to try to be supportive. Mr. Tapp has mentioned a few people that deserve much recognition. Carol Dodge has now become a dear friend of mine. For Carol Dodge to stand up when her daughter had been murdered and begin to listen and to look into what was really behind what happened with Mr. Tapp's conviction speaks volumes for somebody willing to step outside the hurt and pain that has come to both she and her family on behalf of someone else who has been wrongfully convicted. I'm so appreciative of her. And Chris had also mentioned John and Jolyn Thomas, who they are also friends of mine. I feel badly that they're not able to be here, but aside from Carol Dodge, the two people are probably singly most responsible for the fact that Chris is in this position today, notwithstanding everyone else afterwards, but it literally has been John and Jolyn Thomas, who both have sacrificed a ton, more than people will realize, to stand by Chris through all of this. And these people need to be recognized. You know, as we think about what has transpired, we cannot give Chris back 20 years of his life. We can't. I believe Chris would trade those 20 years rather than looking for the compensation that this legislation would bring. As a matter of fact, it's actually a false narrative to just talk of 20 years of his life, because it's actually 20 years of his life, or 25, you know, going back to when this happened, and then every year going forward, nothing will ever be the same for him because of that which he's been through. And so since we cannot give him that time back, we can only help or hope to do the right thing moving forward. And not just for Chris. I mentioned Chris because he's become the face of this legislation. But as he mentioned, Charles Fain and potentially others. When Lady Justice is blind, and as I think back to, I've said this before, but I think back to that which our founders had intended to do with our justice system. Our founders had intended that it was better for a guilty man to go free than an innocent man to go to prison. Unfortunately, in this particular case and a few others, Idaho has failed. It is time that Idaho make right that which we have done wrong. I do ask you for your green light, and I thank you for your time in hearing this. And to Mr. Tapp, he has been a model of forgiveness, a model of somebody who's willing to look forward with hope and to move on with his life and choose to be happy. And I don't think you can ask for more than that. Committee, thank you. And I'll join you again if that's okay, Mr. Chairman.
Give Representative Ehart an opportunity to return to her seat. I see no additional lights, committee. We do have a motion on the floor to send Senate Bill 1027 to the floor with a due pass recommendation, not to be confused with the much confused 1037 that almost got shanghaied today. I guess that the bill's not confused, I am. All right, seeing no commentary, all those in favor say aye. Roll call's been requested.
Representative Hartgen. Representative Kirby. Representative Amador. Representative Ehart. Representative Scott. Representative Marshall. Representative Troy. Representative Young. Representative Nate. Representative Cannon.
Aye.
Representative Erickson. Representative Skog. Representative Gannon. Representative McCrosty. Representative Ruckty. Representative Nash. And Chairman Cheney.
Aye. The roll call shows an unanimous vote. The ayes have it, the motion carries, and the Senate bill will be sent to the floor. All right, committee. Where's the page? I guess we may have before I turn the gavel over, we may have a brief meeting on Friday, depending on if we get some slow to arrive RSs in and a letter from the speaker. And I was hoping to recognize the page since if we don't have a meeting Friday, this would be our last meeting. But hey, there he is. Yes, if you could come on up here. We'd just like to thank you for your time with the committee. I know that it's coming to a close this Friday, right?
Yep.
And would you like to say anything about your experience or what you were most surprised by or anything of that nature?
Yeah, so as my time comes to an end this week, I would like to thank every representative that I got to meet. I got to meet a lot of great representatives and realize that they're people too and that they're very down to earth. I came in with this misconception that they thought they were this big and they're the legislature, but they're actually really nice and really down to earth. So I want to thank every representative that got the chance to talk to me and had a great conversation with them. So thank you, guys.
Thank you. Committee will be at ease. And I'll let you call it back to.
Next up, we will have House Bill 195. The floor is yours, Chairman Cheney.
Thank you, Madam Chairwoman. I believe I have a PowerPoint as well. Thank you. Thank you, Madam Chairwoman, members of the committee. Representative Greg Cheney, District 10 Caldwell, here to present House Bill 195. I'd like to begin by reflecting on some of the things that House Bill 195 does not do. House Bill 195 does not prohibit protest. It defines areas that are less appropriate for protest. House Bill 195 does not eliminate picketing. It defines an area that is inappropriate for picketing. House Bill 195 is not new. It's new to us in Idaho, but in your OneDrive you have an article on Senator Josh Hawley of Missouri. And if you scroll down to where I left a yellow dot on your PDF, you'll see that the criminal complaint filed arises from a Missouri state law that says picketing is illegal in front of a residence. You'll also see in that article where Senator Hawley's wife and children were home alone when the picketers arrived. The prohibited conduct was not dependent on any sort of volume or threat. Prohibited conduct is about picketing in front of a residence. What you have in front of you is language that in and of itself has been tested, tried, and succeeded through the courts. This legislation, and I'll allow Representative Green to speak to it more directly, but we drew from other states that were involved. The intent language is aimed at excluding and not inadvertently outlying other protected activities, such as canvassing, door-to-door sales, and the like. It also is intended to exclude those who may inadvertently picket or demonstrate, or make it clear that simply stopping in front of a house by itself isn't picketing. The intent language does not accidentally discourage all picketing. It is intended to be a modifier of the picketing or demonstrating so that it is truly picketing and demonstrating that we are capturing. My role here in this presentation, at least initially, is to set the stage for where we're at, and I'd like to do that by setting the stage for where we have been with some context. I want everyone to be heard, whether they agree with me or not, but I'm going to, including those who are in the building today, irrespective of their vitriol or their personal opinion of me. But I emphasize the word everyone, because when we turn the volume up this hot on political discourse, we crowd out anybody not willing to be equally as confrontational, angry, loud, or violent. And we've been there before. We've seen this before. Now, I believe that most everyone who is engaged in demonstration has done so with noble motives in mind. But I would like to share with you some points in history where other persons demonstrated with noble motives in mind and ended up turning the heat up so loud or so high on political discourse that there were problems. But first, I would like to prepare you to hear two things today that aren't true. You're likely to hear that picketing at homes is necessary because it's the only place left for people to protest. Something along the lines of, if we're going to go to Zoom meetings, then you create a situation where you can't protest at the meeting. And Idaho law does require there to be a physical presence at the headquarters that would allow for protest, but I'll address that further in a moment. You'll also hear that arriving at homes is not intimidation. When I introduced this bill, I was prepared to come here and tell you that this had never happened to me, but I was sufficiently angry on behalf of the people that it happened to. And I guess I should pause, though, now to share a Rule 80, because I'd like to present to you evidence that those two statements that I just made, that it's not about intimidation, and it's only necessary because there's no other place to protest, are untrue. This is a screenshot I received. The blued out area is my home address. This was posted yesterday. After we posted the agenda showing a 4 o'clock adjournment of this committee, I've been in this building nearly every day of the legislative session. There have been plenty of places that I could have been protested. We publicly posted an agenda with a 4 o'clock adjournment. It is not possible for me to get home by 4:30, not in that traffic. So if it's not about intimidation, then why is it being scheduled at a time when only my wife, my children, and my Labradoodle would be home? You can mess with me all you want, but knock it off, for goodness sake. Again, I'm not trying to demonize anybody, but even the Nazi Party started with good-intentioned persons who were frustrated. And they were used over time to allow bad people to take power. How so? The brown shirts of the stormtroopers, they were private citizens initially. They eventually got absorbed into the government. They believed they were doing the right thing. They provided security to Nazi Party events, including speeches by Adolf Hitler, and they interrupted by force meetings being held by those with whom they disagreed. They were legitimized by government, but then their leadership was killed one night when they got too strong. They remained in existence but weakened because after they had helped people move forward, they themselves were marginalized. Fast forward 30 years. Maoist China, the Red Guard, well-meaning idealistic college students were called upon by Mao to rebel against the four olds, the old customs, the old culture, the old habits, the old ideas. They went house to house, dragging people into the street. Mao himself issued an order that the police not intervene. It was your first autonomous zone. They tore down and destroyed cultural icons in the interest of making a new China. Again, these were not evil people. They were frustrated, well-meaning people. I could show similar slides, though I didn't prepare them, on the revolution.
Could I interrupt you just one moment? The video is out, and so I think we need to go into recess until the video is back
Very
up.
well.
Sorry. Thank you for being patient, and I think we're up and going, and we're going to push because we'd really kind of like to get through this and possibly on to voting before we go to the floor. So we're going to move it on. Back to you, Chairman Cheney.
Thank you, Madam Chairwoman. Let me just wrap up that previous point by saying that when well-meaning people engage in confrontational politics, it gives opportunity for not so well-meaning people to come to power. At this time, I would like to yield to my co-sponsor, Representative Brooke Green, to explore the genesis of the bill. Representative?
Thank you. Representative Green, the floor is yours.
Yes, and thank you, Chairwoman and committee. For the record, Representative Green, out of District 18. It's a privilege to be before you. Primarily, it's a privilege to finally address this. This past year has tested the relationship shared between government and its people. We have seen the dialogue shift from our places of business to our very own doorsteps. It's unfortunate it's come down to this, that for us to protect the sanctity of our home, we actually have to have this discussion. These events have played out in our very own communities, where respected community members found themselves held captive in their homes by angry protesters expressing their rage for simply doing their jobs. This didn't occur just to elected officials. This played out in front of law enforcement homes, county and city employees. Each of these individuals, the common denominator was they all had a place of business somewhere else, and their place of business was not their doorstep. These families had to endure several sleepless nights while complete strangers lurked in the darkness outside their house. They had to shuttle their children out their back door so they could actually not see the objectionable language that was occurring on the sidewalk. For what? What exactly were they trying to achieve? If not only to remind the occupants of the homes, the fearful spouses, the terrified children, that they're not safe. They're not safe in their very home in which they retreat to. The legislation before you is a novel, as Representative Cheney had brought up. It may be new to Idaho, but it's certainly not new around the United States. I'm going to just run off a couple states that have similar legislation on the books. Virginia, Arizona, Colorado, Illinois, North Carolina. Virginia code specifically says those who engage in picketing before or about the residence of a dwelling place of an individual, which disrupts or threatens an individual's right to tranquility in their home. Arizona, residential picketing, if and when the intent to harass, annoy, or alarm another person, such as intentionally engaging in picketing or otherwise demonstrates before, about the residence or dwelling. Let's go down to North Carolina. When the person knows or should know that their picketing would cause a reasonable person to fear for their safety or the safety of their immediate family, personal associate, or cause substantial emotional distress. Let's pause there just for a moment. Substantial stress. What about those poor children who are getting shuttled out their back door because protesters are showing up on their doorstep, that they can't go out their front door to go for a walk or walk their dog, see their childhood friend down the street? What do you think that's doing on their emotional well-being? And lastly, currently in our neighboring state, Utah has just introduced its legislation and it has reached its first reading. This isn't the first time the Idaho legislature has addressed this questionable speech, as several of us can recognize that even protected speech is not equally permissible in all places and all times. In 2007, Idaho added to its Disturbing the Peace statute a provision that makes it a misdemeanor for anyone who willfully disrupts a memorial service, a funeral procession, or a burial ceremony. This provision was added in Idaho and 45 other states following the egregious behavior of picketing soldiers' funerals. Our society has been grappling this for generations. Where do we draw the line? Where does your right to free speech infringe on my rights for my family's well-being, the tranquility, and the privacy at our homes? As addressed in Frisbee and Schultz, the First Amendment permits the government to prohibit offensive speech as intrusive when the captive audience cannot avoid the objectionable speech. Furthermore, they go on to note the unique nature of our home as the last citadel of the tired, the weary, and the sick. Preserving the sanctity of our home, the one retreat to which men and women can repair, they can escape the tribulations of their daily pursuits, is surely an important value. I'll leave you with this. If the last place that we can all retreat to is our home, where else, if we can't go home, are we to go? What we have before you, as brought up before, isn't new. This isn't some legislation that we thought up because we saw our friends, our colleagues, our neighbors get terrorized in their homes. Other states have already done this. The unfortunate thing is we're having to do this because what is unfolding in our homes and in our communities. And it's not just a certain group of individuals. We're seeing this across the spectrum. It is up to us to be able to restore that tranquility of our homes and ensure our community members, not just elected officials. It could be that publisher who printed in the newspaper the wrong article. This provides them protection. It's the barber, it's the dentist, it's the cop. We are instilling that they can go home, tuck their families into their beds, and ensure that what occurs on their doorstep isn't going to be intrusive. So with that being said, I'm going to yield my time. We're open for questions. I'll call Representative Cheney back up here. Thank you.
Thank you, Representative Green.
Thank you, Madam Chairwoman. I will make my next points quicker than I was planning on. I was going to spin a yarn about going on recess here in the committee and using the restroom and having somebody kick open the door and take issue with you over your vote on the floor this morning as an illustration of the fact that there are places where protest and privacy just don't mix. But I won't labor there. This is Frisbee v. Schultz. Representative Green referenced it earlier. It is in your OneDrive. It is from 1988. That we are often captives outside the sanctuary of the home and subject to objectionable speech does not mean we must be captives everywhere. What about our disturbing the peace statute? Well, what about it? Here in State v. Poe in 2004, the Idaho Supreme Court invalidated the obscene speech portion of our statute. And in so doing, they commented that although the government can, by a narrowly drawn statute, constitutionally prohibit the intrusion of unwelcome speech into individuals' homes, vis-a-vis Schultz, this statute is not narrowly tailored to protect that interest. Unlawful assembly requires loud and boisterous conduct. My final point is this is not confined to elected officials. I was watching a show on television last night with my wife. This guy had been wrongfully accused of murder that he had absolutely nothing to do with, didn't even know the person, and we just addressed that issue here. But now in the social media age, his face, his address, everything was put out there. He was harassed endlessly to the point of a suicide attempt. Mob rule is not appropriate, whether you're the falsely accused, elected official, or a police officer. This bill has been crafted in such a way that does not specifically target political speech. It targets all speech. So all picketing is prohibited. At this time, I'd like to yield to Diane Lasciando, who I believe is here via, with the chair's permission, yield. She is via Zoom, I believe.
That's great. Thank you, Chairman Cheney. We will now have Diana Luciando. Do you have her on there?
Hi, can you see me? Yes? Okay.
No. What's that? Tuck it down. Yeah, take it down.
Thank you so very much, Representatives Cheney and Green. My name is Diana Lasciando. I am a resident of Boise. Until recently, I was serving as an Ada County Commissioner, and in that role, I was asked to serve as a Central District Board of Health member. Many of you saw what took place on the night of December 8th, and I won't go into too much detail as ultimately it was shared really all across the country. I was in my office at the Ada County Courthouse participating in a meeting when I received a frantic phone call from my 12-year-old son. He shared with me that there were protesters outside the house. They were banging loudly, they were playing loud music, and he noticed that one of them was open carrying a firearm. He was very concerned, very scared. Truly, the fear in his voice was palpable. And what many of you may have seen on video was a mother I can't even explain to you, just complete fear for my children. And more than just their physical safety, their emotional well-being, because I knew how terrified they were. What many of you did not see, however, is what happened the next night. The next night, there were similarly protests at our home, the night of my 9-year-old son's birthday. As had happened earlier in the summer, when protesters disrupted our home on my older son's birthday. The protesters who came on December 8th were sufficiently loud that they warranted a disturbing the peace charge from my neighbors. However, protesters had been at our home for other reasons at other times and did not warrant that type of charge, and were able to continue coming and targeting our home. What I really can just share with you is how this has affected our family. When you have children, it's normal for them to sometimes be scared of what's happening in the world when they read the news or hear stories. And I have always assured my children that Idaho is a safe state and that Boise is one of the safest cities in the country. But it's difficult to assure them of that when we were personally being targeted. And I can tell you that it led to my youngest son sleeping on our floor for a number of weeks out of that concern. I think more than that, one of the larger concerns that I have for our community and certainly our democracy is, what will this mean for people who may want to run for office in the future? I have had a number of women reach out to me and share that they had considered running for office someday in the future, but now would not because of their fear for their family being targeted. And I think that's a big problem. It really calls into question how we can function as a citizen democracy when average citizens who don't live in gated communities, who don't have the luxury of hiring private security guards, are not feeling like they can participate. We all value our rights in this country, and certainly our First Amendment rights are critical. I also would echo Representative Green and Representative Cheney that there has to be a balance between those First Amendment rights and our rights to privacy and safety. And I applaud them for seeking out this legislation that tries to find that balance. I'm happy to answer any questions you may have.
Are there any questions? I see none. Chairman Cheney?
Madam Chairwoman, may I next yield to Sheriff Karen Donahue?
Yes.
Thank you.
Sheriff Donahue?
Thank you, Madam Chair. For the record, my name is Sheriff Kieran Donahue, Canyon County, and today I'm representing the Idaho Sheriff's Association. There's been a lot of testimony already that is quite pointed, and quite frankly, in my opinion, some of the testimony you've heard here today that would pertain to this bill came from the two bills before it. When we heard from the AG's office and his investigators about the things that they investigate. As a detective in my past, and looking at those cases, think about all those people that work for the Attorney General who investigate some of the most heinous crimes that face our population. Pedophilia against children. Is it okay for someone to go and find out who those investigators were because they saved children, and then we're going to allow targeting and picketing at their household because of the job that they did? I think that was a very pointed part of today's discussions, and that's just one of them. The wrongful conviction. This body moved that bill forward with a due pass recommendation. So would it be fair for those who don't believe in the equaling of the balance of justice on wrongful conviction to come to your house tonight because you moved that bill forward, the due pass recommendation? Rightfully so, I may add. I support you in that. But then you can become the target of that, of those mob attitudes that these guys should be in prison regardless. Well, they shouldn't be in prison regardless because they were innocent. So keep that in mind as you discuss this and debate this today. The Idaho Sheriff Association strongly supports House Bill 195. We, on a daily basis and nightly basis, try to protect you and society and uphold the rule of law. As a sheriff, we are constitutional officers, and those who work for us work under that auspices, that we support and enforce the rule of law in this country, and specifically in this state. As has been mentioned, there's a lot of turmoil over this last year, 2020 especially, but that agitation should not be taken to people's individual houses, whether you're an elected official, whether you're a police officer, one of you all. That should be debated here in this house, which is what we're doing today. We're testifying, you will later debate. That's the democratic process that we enjoy in this country and specifically in this state. That's how it should be done. If you don't like something, voice your opinion, do peaceful protest. As a peace officer, I'm going to protect your right to peacefully assemble and to protest on the steps of this very building. But to take it somewhere else is unacceptable. The place for the discussion is here. Public officials acting in good faith should not see the intimidation and the tactics at their homes, nor should their neighbors have to encounter such distractions merely because they had the audacity to live next door. It's not fair to those people either. Why are their peace and serenity being disturbed because this person or persons do not like how you voted or how I upheld the rule of law? Come to my office and talk to me. Make a call. We will come to your house and talk to you. We will talk to you on the street. But your families, ladies and gentlemen, do not deserve that. Your children, your grandchildren do not deserve that. And there needs to be a separation of that. What can be done? Because you had the audacity to be a public servant, to sacrifice your time away from your home, your evenings, your weekends, your whole entire 3 or 4 months of this legislative session because you believed in something greater than yourselves. And yet someone who disagrees with you can come to your house while you're not there, your place of business. They can come here, they can come to their representatives, their senators, and they can debate it in this legislative body. Without this bill, you, we, the men and women of this state, stand in somewhat peril of falling into the same chaotic mess that we see across this country, that we don't agree with. We don't agree with it in Washington. We don't agree with it with senators and congressmen, legislators, mayors, or councilmen being attacked at their own homes, prisoners of their own homes because of this mob mentality. It's unacceptable. This is a small measure to put in place to prevent that, not just because we're law enforcement officers or because you're a legislator, because it's the right thing to do. You don't deserve it. And we will stand in protection. The very law enforcement officers that we're talking about are going to get in their cars, leave their dispatch center, leave their office, and come to your aid day and night while their children and their families are home potentially facing this because, again, they took up that role of service and were called to that duty, and they fulfilled that duty. So I'd ask this body to carefully consider moving this forward and consider it not for Representative Cheney, Representative Green, who I support in this, but those of you who could be the next target of that animosity at no fault of your own except that you voted your conscience, which we asked and elected you to do so. So please move this bill forward. You certainly have the support of the Sheriff's Association. Madam Chair, I will stand for any questions.
Thank you, Sheriff. Are there any questions of the Sheriff? Seeing none, thank you.
Thank you, Madam Chair.
And next we have one virtual, Steve Smiley.
Thank you, Madam Chair.
I'm sorry, Representative Young.
Can you all hear me?
Oh, I'm sorry.
Thank you. Can you hear me?
Yes, we can hear you.
My name is Steve Smiley. I reside in Meridian, Idaho. And a little bit about my background. My father, Robert Smiley, was governor of Idaho for 3 terms. And I grew up from ages 1 to about 13, as a child of a public figure. So I knew very well what it was like to be in school and sometimes be made fun of because of something my father did, to the point one time to where I never knew it, but somebody made a threat that, Governor, I know who you are and I know who your children are and I know where they go to school. And very quietly, a state patrolman followed my brother and I to school for several weeks until they figured out who this person was. So I've experienced this. Nobody did anything. But, the sad thing is today I read in the paper that officer, one of them, passed away at the age of 87. And I remember him. And what a good man he was. Anyway, let's talk about the subject at hand. I also served in this body for 4 terms. And I also served on the West Ada School Board for 4 years. And we handled many controversial things. I had seen many demonstrations. At West Ada, we had a number of people that demonstrated at meetings. We allowed many of them to come in and air their grievances. We debated, and many of the people had legitimate points to make and had every right to protest and every right to picket and every right to have signs. And these people were given every opportunity to do so. But what this bill is talking about, and I speak in favor of this bill, is that it draws the line that I'm fair game. As an official, you can protest all you want, but your children, your families, your home should be your private property, and you should be allowed to enjoy your property without having these kind of demonstrations take place. I happen to know many of the people that were involved in this, and there were incidents that happened in my neighborhood of where people came and protested in the park and other places like that as well. There were a group of people that set up a table just a few blocks from my house and, protesting some of the things that were done by the West Ada School Board. So that is legitimate. That's okay. And I think this bill simply tries to draw the line. It simply says that there needs to be a little bit of sideboards on the freedom of speech that allows people to have a private life. And with that, I could say much more, but I will stand for any questions.
Thank you, Mr. Smiley. Are there any questions of Mr. Smiley? And Representative Young, I apologize for not seeing your light last time. Okay, are there any questions this time? All right, thank you, Mr. Smiley. Do we have the other person, Mr. Cheney? Let's see, Ryan Rhodes. Are you in the audience? Yes, thank you.
Madam Chairwoman, members of the committee, I thank you for being able to speak with you today. I'm here on behalf of the Fraternal Order of Police. I'm the Vice President for the state of Idaho.
Could you state your name for us?
Ryan Rhodes. I'm here to speak on behalf or in support of House Bill 195 on behalf of my 2,355 members across the state. I will try to speak up, and I will be brief, I promise. Many of the talking points that I have here today have already been addressed. We're aware of multiple incidents, not only across the nation, but here in Idaho specifically, where people's houses were targeted for protests simply because they did their job or went with their conscience if they're in a legislative body such as yours. Protests have a time and a place, right? If you protest after a certain time of day in a loud and boisterous manner, it can be considered disturbing the peace. Similarly, as was already addressed, you can't protest at a funeral, and this body enacted legislation to address that in 2007. Also, it's been addressed over time, as early that I could find in my limited research, as 1988, again in Frisbee versus Schultz. I just want to speak briefly on the effects that can have on staffing for departments, especially smaller departments. I work for a medium-sized agency. However, smaller departments have limited resources, and even my department has limited resources. We only have so much manpower, and it is getting more and more difficult with things like the protests and just the current state of the nation to find qualified individuals that want to come out and stand that line and make sure that everybody's rights are protected, including those that are receiving the protest and those that are protesting. Not only is it an increased risk for the officers that are protecting that line and protecting your rights, it is also a risk for malfeasance on the actor or on some actors that may want to cause a bigger issue that is outside of the scope of that protest, as well as for the people that are being protested. Again, we're there to protect everybody's rights, but there is a time for that. There is a place for that protest. If you want to protest my actions or my voice, I have an office. Come and protest there. My children should not have to see a protest, whether it's vulgar language or the sentiment simply for me doing my job. Nor should they have to see that protest from you voting from your view and your conscience for your constituents. We elected you to this body. Our time and place for protest is through this democratic process. Lastly, I will just address the morale that I've seen affected, not only on the officers that have people show up at their home to protest, but also the family members of those officers. I know there are officers that have quit this job because of the state of upheaval and the protests at individuals' residences. They do have young children. They don't want them subjected to that. They don't want those risks associated with that. So I'd urge you to support this bill, support it moving forward, and with that, I will stand for any questions.
Thank you. Are there any questions? Representative Nate?
Madam Chair, seeing the lateness of the hour and that the House is due to go on the floor in just several minutes, I move that we adjourn this meeting and take up the testimony at the next meeting. Thank you.
It's been moved and seconded. Is there any discussion?
No discussion on adjournment. I don't think you can have a discussion on adjournment.
Roll call vote. There's a roll call vote on the motion to adjourn now.
And take up testimony next meeting.
Okay, so the motion is just to adjourn, not to have testimony on another day.
Madam Chair, point of order.
Yes, go ahead.
The motion was to adjourn and take up testimony at the next meeting. If there is, the question that I have for the chair is, will there be testimony at the next meeting?
Well, Representative Nate, that depends on how much time we waste on the floor of the House, because we would have had plenty of time today had we not had
Mr.
silly
Chair, that's out
tactics.
of order.
That's out of order.
Well, I believe it is out of order. The chair's ruling is a motion to adjourn is a motion to adjourn, and it is not able to be appended with a motion to take testimony. So we have a motion on the floor. It is non-debatable. Your questions are taking the form of debate. We'll
Mr.
have a
Chair,
roll call
the
vote.
question is, will there be testimony at the next meeting?
You're out of order.
We need to adjourn.
Commencing with roll call vote. Representative Cheney,
No.
Representative Hartkin,
No.
Representative Kirby, Representative Amador, Representative Ehart, Representative Scott,
Yes.
Representative Marshall. Can you repeat that? Aye. Representative Troy. Representative Young. Representative Nate. Representative Cannon.
No.
Representative Erickson. Representative Skog. Representative Gannon. Representative McCrosty. Representative Ruckty. Representative Nash.
All right.
That would be 3 ayes and 14 nays. One isn't present. Excuse me, so that would be 13. Nays.
The nays have it. The chair would entertain a motion, or without objection, we can either go at ease or we can, without objection, adjourn until 10 minutes following floor. Is there an objection?
Object.
All right. The committee will be at ease. Madam Chairwoman.
Yes. Mr. Chairman.
We want remote testimony to be uniform, but we do not want people to not be heard. I have proposed that we hear the people that are still here, and then, with the committee's permission, postpone further consideration until Friday for those who signed up today, only those who signed up today, but could testify on Friday. Our desire in not adjourning earlier was to hear you out, everybody. And I think in light of the technological issues, that the best solution is to hear everybody who's still here and come back on Friday and hear more testimony if the committee is open to that. It's a committee decision.
Okay, I'm seeing shakes of heads, so we will resume, and you can have Rosa come back on Friday if she wants to testify in person. Okay. Thank you. Thank you. Tawny Brunner. Sarah Brady.
Thank you, Madam Chairwoman and committee members. My name is Sarah Walton Brady. It's been kind of a long way to get this point, so I'm sorry if my thoughts are now not very solidified. But, listening to you earlier, Representative Cheney, we've had our differences politically, but I've had the same feelings that you've had in regards to someone coming to a home. So about a year ago, I was arrested for going to a playground. And I'm not an elected official or anyone special, but it just happened that I made a lot of people mad accidentally. There was about 3 or 4 nights I was incredibly scared, and there was word somewhere on social media that I had been doxxed and people had planned on coming to my home, and law enforcement locally were so concerned that they reached out to my husband and let him know that they were going to be patrolling the area. And I know it's like to be in a political climate where people might show up to my home because my husband's a police officer. I know what that's like. And it's not a fun feeling. So I identify with that feeling earlier that you had, Representative Cheney. But the thing is I'm really, really aware, being married to a police officer who's made an oath to the Constitution, that there are constitutional reasons for protest. And I understood that if someone showed up to my house and didn't step foot on my grass or my front porch and they were still on that sidewalk or across the street or at my neighbor's house or whatever it was, that's a legal place to be. And we have laws for things like trespassing and disturbing the peace. So I would urge you guys to vote no on this. It's not constitutional. It's just not, despite the fear that I've been through. I still don't think it's right. Thank you.
Thank you, Mrs. Brady. Del Chappell?
Chair and committee, my name's Del Chappell. I'm in District 11. You know what? I'm going to urge you guys to vote no against this. And I think the question we need to ask ourselves is, why are we in this position? How did we get to the point where I feel it's necessary that I need to go to somebody's house and let them know I am not happy with what's going on? How did we get here? Well, we got there because we weren't allowed to go to the meeting location. We weren't allowed to go in the building. Yeah, they did have one person there, although there's 7 people voting, say at Central District Health. So why would I feel the need to go to their personal residence? It's because I'm not being heard. That's why. I'm not being heard. And when I feel like I'm not being heard, I'm going to go someplace where I can be heard. And that's it. These are the people that are making rules affecting my life. They're trying to tell me, hey, you can't even have 10 people in your house for the holidays. I'm like, what the hell's going on, man? Where am I? Have we lost our minds? Yeah, I went to a targeted protest and I freaking hated it. It sucked, man. I hated it. But I felt I have no option. I'm out of options. Where do I go? I have my legislators they're stuck at home. My governor, he won't even call you guys into session. He did the wrong thing. He should have called you guys into session so I feel some sort of representation. I mean, that's how we got here. So now we're going to make another law that says, shut up, people, shut up. We don't want to hear from you. That's it. That's all I got. Thanks, guys. Thank you for hearing me.
Thank you, Mr. Chappell. Adrian Marcus? If I mispronounce names, just let me know. Stephen Kaiser? Rick Schulten, or Schult? Camin Glancy. I'm trying to read these names. Eva Schellick. Mrs. Schillick, you might pull that mic down where we can hear. There you go.
Thank you for allowing me to come and testify. I had a different
Would you give us your name for the record?
I'm sorry. I'm Eva Selleck, and I'm going to out Greg Cheney. I probably have known him longer than anybody in this room that I have known. And I want to express my appreciation for him listening to me yesterday and meeting with me and discussing the challenges that I'm having. And I'm sorry, I have the Constitution, I have the things available here to back it up, but I have witnessed the things, and just because I am a friend with Greg doesn't mean that I can't disagree with some of his ideas or thoughts, and we still be friends, I hope. Is that right? Representative Cheney, I'm sorry, Chairman Cheney. In the Constitution, it gives us the right to redress our grievances. And I had been going to Central District Health for months, and they decided that they were going to discriminate against the people, and so they said, if you come into this building, even if it's a public building that you pay for, and it's a public meeting that you have attended for months, you will be arrested. And so now I am the poster child for being arrested for not wearing a mask because they were discriminating. Now I am standing down at the courthouse, and because I will not do TV court and I will not put on a mask or do court in secret, now I am being discriminated against down at the courthouse, and it's been since the 20th of October, and I do not even have a plea in. And they charge me with failure to appear while I'm standing on the front of the courthouse steps. So we need to do something to get our state back functioning in the manner in which it is supposed to function. Thank you for your time. Is there any questions?
Does anyone have any questions of Mrs. Sellett? Thank you so much.
I have a question.
Oh, okay.
I'm sorry.
I'm sorry.
Yeah.
Representative Gannon?
Yeah, we're running late on time, but if you'll stay around, I'll be happy to talk to you afterwards.
Thank you.
Thank you again. Any other questions? Ryan Rhodes? Okay. Okay. Monica McKinley?
We have a page that can pass some things out to the committee members.
Pardon me?
Is there a page that we can pass, that I can pass something out to the committee members?
If
Or I can real quick, I guess. I can put them here, you can just pass them down if you
No,
like.
no, if you have something, you need to give it to a page, and he will bring it up to the secretary. Just bring it up to the secretary. Thank you.
That's a reference for when I start my testimony.
Do you have something to say, Monica?
I do. Do you want me to start now, or are they going to
Yes,
is she
start
going to
now.
pass that out?
State
Okay.
your name.
Chairman, members of the committee, my name is Monica McKinley, and I'm from District 20. And the pages passing out are supposed to be passing out a pamphlet that I would like you to direct your attention to the clipped page. On the small ones, it's 21. On the large ones, it's 77. The first paragraph, it states, and I quote, "Congress shall," I repeat, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. That last part again, and to petition the government for a redress of grievance. I need to ask why are you considering a bill that is a blatant violation of our constitutional rights? Who voted to print this? Did you read this RS as it was sent through yesterday, the print hearing, with 8 other unread routing slips? Yes, we noticed. Even though it was not originally on the agenda, it miraculously appeared, violating the 24-hour notice rule, and now we have unequal time. The presenter's agenda has made it so that we have 2 minutes, and they had at least an hour and a half. Again, what is the purpose of this bill? If politicians are going to hide in their homes and conduct virtual public meetings. They shouldn't be surprised when people show up in the public streets there to protest. Again, public streets. When you take the government to your home, the people aren't at fault for coming to their government. If you do government business on a private server, that government business on that private server belongs to the people. If you do government business on your phone, that government business on your phone belongs to the people. If you do government business from your home, that government business in your home belongs to the people and is subject to a petition for the redress of grievances. Now, we've been locked out of the governor's office, the attorney general's office, city hall, the courthouse, and CDH. And officials are not returning our phone calls or emails.
Ma'am, your time has expired.
Can I conclude?
No, your time has expired. Thank you.
That just proves my point. Thank you.
Jessica Yurikin? Sorry if I've missed your name.
My name is Jessica Marco, and I'm from Nampa, Idaho, District 13. Please do not pass this unconstitutional bill, which infringes our rights. We have the right to be on a sidewalk or street, which is public property. All political power is inherent in the people. So we have the right to exercise our liberty. As long as there is no damage to property, these government officials violated our rights by issuing unconstitutional orders against our rights, ordering us that we are not allowed to have people over to our houses. Which, if I want to have as many as I want, I have to have the right on my property to have as much as I want, not limit of 10 or less. They closed our churches and local businesses. So if you think that you can infringe our rights in our homes, then we have the right to let you know that we do not accept communists to attack our homes. One thing I have to say is, if you guys would have left our houses alone, we would have left your houses alone as well. We have the right to peaceably protest whenever we deem it necessary. Because all we want is our voices to be heard. And if our voices are not allowed to be, oh, you're not allowed there, you're not allowed there, then we have to go somewhere where the voice will be heard. And if it is the house, it is the house. It was only, if it's on the street, it is public property. It is not private. As long as nobody destroyed any property or anything, we have the right to tell you guys that we do not accept those unlawful orders that are being passed to infringe our rights. Thank you so much.
Thank you. Thank you so much. Robert Jones?
Hello, my name is Robert Jones. I live in Nampa, Idaho. I was one of the individuals outside of her house protesting. I've been politically active for about 6 years now. Before that, I was a hermit. Okay, I've come to lots of these meetings and I've heard lots of testimony where everybody but the sponsors are against the bill and you guys passed the bill anyways. But there's a pretend voice there. Okay, I attended CDH, the public meetings. And you may say, well, you live in Nampa. Why does that affect you? Well, because my wife comes home with a headache every day because she's forced to wear a mask at home or at work. She's harassed. She gets complaints from people because her mask, she touched her mask. Her mask wasn't official for them. So I went to the meeting just to listen. I didn't even have an opportunity to speak in that meeting, and I knew that. I just wanted to be present. And I was arrested for trespassing at a public meeting. I was causing no disruption. I sat there and was trying to follow along as best I could through their speakers. Okay, so I needed to take it to the next level. Like I said, I used to be against it. Okay, why I got involved in politics, because they stole my family. CPS took my family, even though I was a licensed foster care provider, because I reported sexual abuse. I didn't go to their homes because I didn't think that that was proper at the time. That's my family. That's someone I love deeply. I didn't go to their homes because I thought that was too far. I did think about going to their businesses they had outside of it, but I thought that was too far. Now, through the silencing of we the people, you're not even pretending to listen anymore, it will continue to escalate that. And like the lady said on the thing, this is not how we do a citizen republic. You're right, this is a constitutional republic. If you want a citizen's republic, that's the Republic of China, the People's Republic of China. We are not communist. And we will still have our voices heard, whether you pass this law or not. I just hope you don't, because it will only escalate it further. Another thing we don't have in Idaho, riots, property damage. That's what happens in those other states where they stop people from being able to peacefully do it. Please allow us to continue to peacefully address our government with our grievances. Thank you.
Thank you. Melanie Jones?
Hi, guys. My name's Melanie Jones. I'm going to read this. I'm Robert's wife. I am against the bill, and I'm going to go ahead and say this. Good afternoon, Chairman and Committee. Whenever the people are well informed, they can be trusted in their own government, with their own government. And whenever things get so far wrong as to attract their notice, they will be relied on to set them to rights. That's Thomas Jefferson. This bill is a direct violation and infringement upon the First Amendment of the Constitution. It vastly restricts the people's ability to seek redress of their grievances in a peaceful manner when all the avenues in doing so have been cut off or exhausted. The past year, the people were restricted their rights to access public meetings in which they have legal constitutional right to be physically present, looking the person in the eye, asking questions, and submitting public comments in person. The inability of the people's voices to be heard and conflicts going without resolution left the people voiceless. A sense of distrust and feeling of frustration rose to high levels, filling the air in the state of Idaho between the people and their public elected representatives. The unconstitutional edicts which have taken place behind closed doors were sought to dictate every aspect of the people's lives, therefore forcing the people to what options remained within their legal right. Taking up nonviolent peaceful protests in a desperate attempt to finally reach the attention of their public officials. Their unheard grievance taken to the place of private residency or business as a last resort. All while saying on public ground so as to not trespass nor cause damage to person or property is well within the rights of the people. So long as the protest remains on the public grounds following city ordinance guidelines of disturbing the peace time frame between 6 a.m. and 10 p.m. and having caused no damage done to the property or person, there could be no violations upon the person being protested against. Therefore, nothing more than an annoyance. This bill is absolutely unnecessary as there are already laws in place to address such violations of trespass or property damage to person or property. The right to peaceful protest and expression protected under the First Amendment must remain intact to its fullest extent, unchanged. Those who make peaceful revolution impossible and will make a violent revolution inevitable. There is no act, however virtuous, for which...
Thank you, ma'am. Your time is up. Thank you. Don Clemeno. It's either Don or Dave. Don.
Dana Clemo.
Thank you.
I just have a rhetorical question. Why are we considering an unconstitutional bill? Thank you.
Thank you. Mario Pira? Is he here? Jennifer? Is Jennifer here? Are you Mario?
No, Mario's on his way. They just texted him. He's in the overflow room.
She can probably hear us, Mario. If you hear, if she's in the overflow room, she can come. We'll give her time to come up.
No, Mario.
Mario
is. Mario's in the overflow room.
You're Jennifer.
Yes.
Jennifer, you come on up and Jennifer, come up and testify. And if Mario is in the over room, she can come up and she can testify after you. Go ahead, Jennifer.
I don't even know what I want to say to you guys.
Pardon?
I'm sickened by the behavior I've seen today with Greg Cheney. You grabbing the gavel away from the chairman to get your way is total bullshit.
Let's stick to if you want to testify on the bill that is before us.
I am testifying on the bill.
No, you cannot smear someone else in here. You just testify about the bill, and I will allow that, but I will not allow you to smear someone else. Just testify about the bill.
I've been watching this circus go on with you guys since January. You guys won't end the emergency. We're not being heard via email. We're not being heard via phone. We're being limited in our time here to testify in front of you, and you guys are not allowing us to testify by jacking everything around, changing the times. Where are we supposed to talk to you? That's the whole point of this bill, is you guys are trying to eliminate any voice from the people. That's the problem. It's protected under the First Amendment. We have the right to peaceably assemble. And if it's on a public sidewalk, maybe you shouldn't be writing bills that the people don't agree with, and we wouldn't need to come to your homes.
Thank you. Michael P.
That's me. It's my middle name. Ladies and gentlemen, Chairman, or Chairman Hartgen, or is it Chairman Cheney at this point?
Chairman Hart couldn't write at the moment.
Chairman Hartgen. So when you guys were called over to the House
Your
floor.
name, Michael?
Oh,
Sure.
David Michael Pettinger. Yes. My name was one of the ones that I had the opportunity of having my name plastered on the screen by the normal sitting Chairman Cheney. But while you guys went to the House floor, I was arrested. I was arrested and charged with battery of an officer. They just took me up to Ada County. And what they're going to do tonight, because of the mainstream media and the Associated Press, is they're going to smear me. They're going to smear me, and they're going to say, here is a cop beater. Here is a police
Point of order.
beater.
Point of order. Is this relevant?
This is not, no.
This is relevant to
Mr.
what
Peckner?
happened. I'm going to tie it in.
You need to talk about the bill,
Okay. As to the bill.
not your own personal hardships.
Okay. That arrest had to do with the protest. That arrest had to do with the protest at Central District Health. The arrest that came from when the snipers were on the tops of the roofs, the protest before that is what they arrested me for. Because of the open meeting violations by the Attorney General in the state of Idaho, we were kept out of the meeting. And because we tried to enter into the meeting, they arrested me, and now they're going to smear my name, national news, within 3 days. I guarantee it. You guys, by not stopping the state of emergency, by not following the Constitution of the state of Idaho and the United States of America, are smearing me, a law-abiding citizen, until you guys started the sham that is COVID. We do not break the law. We follow the actual law, the Constitution. This is an unconstitutional order. I don't appreciate it. Vote no.
Thank you for your testimony. Dominic Brandon. Sheriff, oh, never mind. Okay. That I don't see did Mario ever make it down? Ma'am? What is your name? Would you say your name again? It's not here, Marty, but if you would like to come up and talk, I will give you 2 minutes. Fine.
Yes, thank you. This will be quick, but my name is Margie Baker, and good afternoon, Chairman and committee members, and I'm very sad to know what's going on, but
Would you state your name again? I didn't.
Margie Baker? Margie Baker. This piece of legislation screams unconstitutional and unlawful. Let us begin with the attempt to amend this bill unlawfully. the legislature cannot amend the Constitution through this process. Article 20 requires a convention for the legislature to amend the Constitution. Not only that the legislature can be called into peaceably assembly by the people themselves, as that is a right retained by the people. See Article 1, Section 2, 10, and 17. A committee may call the legislature into peaceably assembled to conduct business at any time, because in order to do business, a quorum is required. It is unconscionable that a legislator or legislators are even attempting to pass this unlawful and unconstitutional legislation. God forgive you. In my extensive research, I found that there are thousands of case laws that were brought before state and federal courts against the very issue and have won. I dare say that there will be an uproar of the people of the state of Idaho if this were to be passed. According to the supreme law of the land, a breach of peace would not constitute a peaceably assembly. In addition, concerning lines 17 and 18 in this legislation, it is unlawful to punish someone when targeted picketing, specifically restraints on the grounds that may give rise to damages, liability, and on the persons who may be held accountable for those damages. In other words, the states may impose damages for the consequences of violent conduct, but they may not award compensation for the consequences of nonviolent protected activity. In McCollum versus Coakley, the court retained a content-neutral analysis similar to that in Hill, but nonetheless struck down a statutory 35-foot buffer zone at entrances.
Your time has expired.
Oh, okay.
Thank you.
Thank you. Can we submit these?
Yes, you may.
Okay.
Okay, we have two people online right now, Alicia Sherdam.
There we go. Can you hear me?
Yes, I can hear you. I can't see you, but I can hear you.
Okay. Here, if you want to see me. So I am curious, relating to the bill, why the woman was speaking and you cut everything off for quite a bit of time. Are you going to let us know what happened?
Yes, yes.
Madam Chairwoman, stop her timers because this shouldn't take away from her time to testify. So if you could reset it.
Thank you.
I will explain what happened. House rules say we're not allowed to meet when the full House is in session. We have to be done before they reconvene. We were recessed to reconvene at 3:30 upstairs on the 3rd floor. It was my intention to try to take all testimony today. So that's why I opposed the adjournment, and we went at ease instead. It was because we had a session of the full House to return to, during which time we're not allowed to continue to meet as a committee. And that probably should have been communicated at the time that we broke, and for that, I apologize.
Okay, so it had nothing to do with the woman speaking passionately?
No, it had to do with needing to be up on the 3rd floor no later than 3:30.
Okay. All right, and then what I feel is in the bill, it says that if we are to annoy somebody, I totally agree we should not be at people's homes harassing them and scaring them. I agree with that. And I think I heard that we could also picket at the Capitol, and perhaps, I don't know about the businesses, I think it said no businesses. But to annoy somebody, that happens every day. How could that be a misdemeanor? That could be construed as anything. We all have different opinions.
Are
I
you-
just don't know why that's in the bill because it's, it's very open. You could use it for anything.
Madam Chair, if I may. Typically, when you're testifying, if you pose questions, it's not typically a question and answer, but because of the nature of your first question, I thought it appropriate to pause and answer it nonetheless. If you could communicate to us just your opinion on it, as opposed to a Q&A. I mean, I'm more than happy to speak to the point you're bringing up, and I'm making notes, so I can do that when I close. But our odd traditions and customs here, typically there's not a Q&A when you're testifying.
It's interesting. Okay, well, I'll just get down right to it. I believe it is, and I know it is infringing on our rights of free speech and gathering, and so I vote no.
Okay, thank you for your testimony.
You're welcome.
We have Brittany Saraglano. She did not register in advance, but she is online, so we will go ahead and is she there?
Hello?
Hi, Brittany. Would you give us your whole name, and then you have 2 minutes.
Hi, my name is Clara Sigliano. Hello, representatives. My name is Clara. Through this past year, I've seen and heard a lot of terrible things. One of these terrible things I've seen and heard about was picketing. Miss Diana Lachiando's house was picketed. When I heard about this, I was so angry. I am with this bill because if I had my house attacked, I would be scared, angry, and most of all, upset that someone would do this. It is not necessary. Please pass this bill so no one will have to experience this feeling. I encourage you to move this forward with a due part recommendation. Thank you.
Okay, thank you. No. Can you ask a question? What is your question?
I'm a little bit concerned about the testimony or the interview you just produced. It seems to me that a child of that age
Ma'am, no. Ma'am, you're out of order. I'm sorry. Well, if you have a problem, question, ask it later. Come up and ask it. Not.
Here's my question. Doesn't an adult need to be the person that testifies and not a child under the age of 18? All the time. That's my question. Didn't we hear from somebody about that? Yes, there's laws.
Okay, anybody speaking out of turn without being recognized is invited to leave, please. Thank you, and thank you for your testimony, Brittany.
Welcome.
Sir with the suit, I forget what your wife said your name was. I apologize. Please come forward. Welcome.
Casey Baker.
Casey Baker, the floor is yours.
Thank you. Okay. My name is Casey Baker. Been a resident of Idaho for over 55 years. As to targeted picketing, Idaho Constitutional Article 1, Section 10, right to assemble states, the people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives, and to petition the legislature for redress of grievances. In Article 1, Section 2, the Constitution of Idaho, political power inherent in the people. All political power is inherent in the people. Government is instituted for their equal protection and benefit. And no special privilege or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. The state is an inseparable, Article 1, Section 3. The state of Idaho is an inseparable part of the American Union. The Constitution of the United States is the supreme law of the land. Amendment 1 of the Constitution of the United States says, Congress shall make no law abridging the freedom of speech or of the press or of the right of the people to peaceably assemble to petition the government for redress of grievances. And at this point, may I ask, are we a peaceful assembly to redress grievances to our government? And I would like to address this grievance. It is appalling that you allowed 15 to 20 minutes on some of your testimony for your legislation, proposed legislation, and then limit us to 2 minutes. That is appalling, because those were not presenters, those were testifiers for the bill. With that said, I would say, according to the Constitution of the United States being the supreme law, and Senator Green's comments on this law being similar to laws in other states, there are laws in other states that have been passed, and the courts, and specifically, the courts have held to preserve First Amendment rights, targeted measures such as injunctions, enforcement of anti-harassment ordinances, and the use of general crowd control authority is needed, preferable to broad prophylactic measures such as Bill HB195. Thank you, sir. Thank you for your time.
Is Mario back in? Yes, okay.
Tell me when to go.
Mario, would you like to state your name, and you have 2 minutes?
Oh, yeah. Unfortunately, Greg just left because I wanted to chop it up with him a little bit.
You can
My
raise
name's
that-
Mario Perea.
You can raise that mic.
Okay, yeah, my name's Mario Perea. Hopefully I don't get taken away in the hallway for something I did, something I said not too long ago. But anyways, I wanted to thank Greg for this, because I could talk about communism and totalitarianism all day long, and it won't bring people out here. But these actions, these totalitarian actions, this is what puts it in people's feet to come out here and to testify and to disrupt their day. So I appreciate it, because that's what's going to wake people up. I know Greg is saying, he's doing this for peace. He wants people to have peace in their home. This isn't about peace. What about our businesses that are getting shut down? Where's the peace there? He says, oh, go pick it at their businesses, because he doesn't value business. He wants to feel safe in his aggressions towards the people. That's what he wants. He wants to feel safe, so he doesn't want people to come to his house.
Sir?
Yes.
Please just talk about the bill. I am not allowing
Right.
you to
Okay.
malign.
So this
not
isn't about
allowing
this,
maligning.
not having people come to their house is not about securing peace in people's homes. It's so that the tyrants don't have to face their victims. And the power of policing lies within the citizen. We didn't give it to the state, and we don't have it anymore. So if there's a crime, we can investigate the crime. We can go to the perceived perpetrator's house and talk to them and do it in a respectful manner and stand out on the sidewalk. Greg knows all about the police coming to his house, like when he held his children and his wife hostage at knife point. He knows all about it. Peace.
Objection, Madam Chair.
Out of line.
That's inappropriate.
That concludes the testimony for today. We will meet again. I do not have you on my list. Excuse me? Rosa Martinez? Okay. That will be our last one, and we will adjourn. Sir? You had to have signed up previously, and that is the... Excuse me. Rosa, would you please come forward?
Chair.
Give
Thank
us your
you for the
name and
time. My
you-
name is Rosa Martinez, and since you've allowed me time on Friday, I would like to give my 2 minutes to Ryan Davidson, please, and thank you.
But right, Rosa, excuse me. He did not sign up, but you did. Please give your 2 minutes testimony. We've waited all day as well. Thank you.
Ma'am, there were others that have testified that didn't put their name on us either.
I only know of the one on the internet.
Okay, so there was one. A minor.
That makes no difference. We have had minors in here before, ma'am.
But
Okay,
the fact,
if you
ma'am,
don't,
was
if you
that
don't
she
want
did
to,
not
if
sign
you
it
do
up.
not want to testify, this meeting is adjourned.